I just want to get and now we're recording. Hello, everyone. Welcome to JF Capital Advisors Unplugged version 4. I'm Jonathan Falik, founder, CEO of JF Capital Advisors. We've been doing a series of these webinars to address a lot of the questions, a lot of the issues that have been asked that are not being covered, I guess, as bluntly or directly elsewhere on other webinars. We've had a few hundred people log into or listen to the recordings of each of the webinars we've done before. One of the questions that keeps coming up in the normal course of our business, and I'm sure a lot of yours, is labor-related and union-related issues. So no one had a real playbook for this COVID-19 pandemic and environment, what to do, how to shut down, how to deal with collective bargaining agreements. And I asked Jay Krupin, who's a partner and co-head of the, I may be butchering the title, but co-head of the labor relations practice or labor practice at BakerHostetler, and he's my go-to guy for all things labor and union related. I think he's seen everything there is except this COVID environment. So Jay, thanks for joining us. We're going to pick your brain and maybe give us a minute on your background, your firm's background, and maybe give the legal sort of qualifier that none of this is advice to act on, and the thing you could do better, the qualifier you could do better than I can.
Right. Well, thank you very much for inviting me. As many of the people who I think are on this call know of us and we've worked with. I lead the largest hospitality labor relations practice in the United States, and I've been doing it for almost 40 years now. Started out not just being a labor lawyer, but getting an interest in the hospitality world. And as a result of that, those have mixed. We like to say we're like left eye doctors. Not only are we labor lawyers, but we know hospitality. I like to tell our clients we know how to figure out RevPAR. So we really understand the industry. And I've negotiated over 350 collective bargaining agreements, had more than 150 unionized elections, 17 contracts we negotiated last year. So we're really in the thick of this all throughout the country, in almost every city, with every local. And Jonathan's right. The most important thing to realize about our expertise in this, we did our first webinar on COVID on February 27th. We had a program in San Francisco and someone said, there's this thing called coronavirus. And I said, how do you spell that? And they said, this is coming. We're concerned about how this may hit the shores of the US. There was some beginning cases in Seattle, if you remember, and then San Francisco went to an immediate shutdown by March 12th. And as a result, we did a program saying how this may in fact impact the industry. Ever since February 27th, which I can't believe now is almost 7 months, we have been dealing day in and day out on these issues. And they are issues that we've created a playbook, and we feel very fortunate for our clients and our groups that we deal with, that we're helping them through this unprecedented time. So that's where we are, and Jonathan's asked me to help on some of that knowledge that we have to this group, and we're happy to be here.
Great. And again, just for everyone dialed in or logged in, every situation is specific. So take away hopefully some general knowledge and thoughts and ideas and concepts. But if you want to get more granular, call Jay or someone on his team, or call whoever your almost as good labor attorney is. Jay, let's jump into it. We'll start easy. What's the difference between a layoff and a furlough? And why does it matter in the context of regular employment and collective bargaining agreements?
That's an excellent question. When the pandemic started, again back in February, most people thought that this was going to be a short-term issue. If you remember Major League Baseball, pushed back opening day 2 weeks. There was this idea that we didn't know where this was going to go. And so companies began to furlough employees. What's a furlough? A furlough is basically putting people on the bench in a sense, but there's a reasonable expectation of them returning to work. hotels couldn't keep the staffing levels that they had before. So they said, all right, we'll keep them on the bench until things come back. And so a furlough is not a termination of employment. It basically keeps people around, you're just not using them. A layoff, however, is a definitive separation of work. The key is there reasonable expectation of returning to work? A furlough, there is that reasonable expectation. A layoff, there's not. Why is that important? Because in the world that we're living in now, unions are using employees that are on furlough to organize, even though they're not working, and then they may not have worked for 6 months, but they can still be organized because there's a reasonable expectation of returning to work. So those that have employees still on furlough that have non-union properties have to be aware that they're at risk, that those employees could organize, and the unions are using that for purposes of saying, we're going to get you your job back, we're going to give you recall rights, we'll give you health insurance, you'll get some type of severance. Why wouldn't you sign up with us? Because this has lasted such a long time, a lot of companies are now changing their furlough into layoffs. If you're laid off, you don't have a reasonable expectation of return to work. With the furlough, with the layoff comes the obligation of paying out usually accrued benefits. So some companies don't want to lay off people because they have to pay out accrued vacation or other types of benefits. With a furlough, you generally have to maintain health insurance. With a layoff, you don't. So at first, when the pandemic occurred, the terms furlough and layoff were interchangeable. But now there's true legal significance to it. So the bottom line is, if you have a non-union property, and you have people that are furloughed, the union has a great opportunity to organize them. If you lay them off, they do not.
So Jay, we're seeing a lot of people that have large, big box union hotels in New York, San Francisco, Chicago, union heavy markets that are scratching their heads trying to figure out if hotel is still the highest and best use, or if they should convert to residential, multifamily, some sort of office or other use. So within the collective bargaining agreements they have, can they do that? What do they have to do or not do in terms of obligations under existing collective bargaining agreements?
In a simple word, the answer is absolutely, you can make that change. Remember, unions only control or deal with, there's a duty to bargain over wages, hours, and terms and conditions of the employees, but not the way you operate your property or the services that you offer. So if you have a hotel and you decide that the hotel isn't for you anymore, and you could do better by residential, or you could do it by commercial, or you could do it by making condos, yes, you can change. The union cannot stop you from changing your method of operation. And if you look at collective bargaining agreements, they generally say that it applies to a hotel operation. So we have clients and we have people have asked us, can I get out of my hotel and change it into the type of operation that I want to have? The answer is absolutely yes. What are the concerns, though? You may have in collective bargaining agreements in certain major cities where they have had this conversion, that you have to have some type of severance payout. That if you're going to change to you're converting a property, that employees are going to lose their job, and as a result of that, there'll be some type of remuneration or a continuation of health care or something of that like that nature. But as to the specific question, can you make the change? The answer is yes. The union cannot stop you from changing your form of operation or the services that you want to operate. We have one client that has a hotel that has 400 hotel rooms. There's no way that they're going to be able to maintain 400 hotel rooms in the COVID recovery world. They've decided that they're going to go to 250 hotel rooms. And the remaining part of the hotel, they're going to renovate it and turn it into condominiums or some type of residence. That we're hearing more and more of that. For that purpose, the decision is not an issue you have to negotiate with the union is. Where you have to negotiate with the union. The effect is a negotiated item of how that affects the employees, but it's never the decision. The decision cannot be put into the arms of an obligation to bargain. The effects will be bargained, and those are things about how you make payments as a result of the decision that you come up with.
So Jay, sticking on that same theme with the 400-room hotel, if they decided to stay as a 400-room hotel but eliminate room service, eliminate eliminate the free breakfast, maybe eliminate the entire banqueting and catering operation and just have a simple restaurant operation, can they, and at the same time stop their bellman service, stop their concierge service? Can they do those things, or do they have to go get permission or approval under the terms of any CBA?
You do not have to get permission. And in fact, that's where a lot of the discussions we've had over the last few months have been. The way a hotel will operate in 2021 is not the same way it's operating in 2019. Do we really want people touching our bags? Do I really need a bellman? Do I want to have a touchless system for coming to the hotel and checking in? Do I really want to have a breakfast buffet? Do I see in certain cities banqueting coming back in the next 3-4 months? As a result of that, we could make those changes. Those changes are decisions that belong with the employer. Again, the union only controls the wages, hours, and terms of the employment, but not how you operate your property. They're not your partner with respect to the operation of the property. So yes, you can do that. Now, the big issue that comes up is, can you take certain services and change the job that somebody does? For instance, I don't want bussers anymore in my food and beverage. It's an extra cost. I'm trying to reduce my cost. I'll have the server do the bussing. That you cannot do because you're changing a job description of a union member. So you can change the job duties, but and it's hard to, in a food and beverage, to eliminate a busser job because someone has to clear the
Someone
table.
has to do it, yeah.
So that's one where someone has to do it, and it's difficult in that one to say, well, I'm just going to get rid of bussers, but I am going to and change that job to servers without bargaining with the union. But let me give you another example. IRD, in-room dining. Can you just eliminate in-room dining? Absolutely. So long as no one else is picking up in-room dining. And basically you just don't have it anymore. Or mini bar, or getting rid of the bell staff. Those are legitimate things that you can do. You may have in your contract an issue about how you have to pay out some type of severance because you're eliminating a department or a job. But as to the decision, absolutely yours. There is an obligation to bargain over the effect of that. And the duty, notice I said to bargain over the effect. There is no obligation to reach an agreement. There's an obligation to bargain in good faith. Most employers want to be able to take long-term employees and have them have a soft landing. It's also good business practices. But you don't have any statutory requirements of how you engage in effects bargaining. That is open-ended, like any other bargaining process. So crucially, you can change, and most hotels are what we call repositioning. And why? Because you can't operate a hotel in the future the way it's been run in the past. So you have to reposition your hotel, and we're doing a ton of that type of stuff all across the nation.
Jay, does the same concept work for housekeeping, where we obviously would not be eliminating housekeeping departments, but in a lot of places we've gone to cleaning rooms every 3 or 4 days, or only on a checkout, and sometimes only on a guest request. And I think a lot of that is going to stay in a post-COVID environment. You're going to see luxury hotels will probably still offer the daily housekeeping. When you get into a Hampton Inn, a Residence Inn, a Homewood Suites, you're probably not going to see daily housekeeping unless someone is willing to pay for it as an a la carte service. Do you think that's going to be a big issue, because we're not eliminating housekeeping as a department, but we'll be consuming a lot less housekeeping hours?
The issue of daily cleaning, which is a major issue in the hotel unions across the United States, is not a mandatory subject of bargaining. the idea of when you want to clean rooms, whether it's every day or a 24-hour period of a hiatus to deep clean a room or to keep a room dormant, that is within management rights. The unions want to have daily housekeeping for a very simple reason. They want to bring more of their members back to work. And the only way they could bring them back to work is to have cleaning required every day. But you do not, but that is also something that is not necessarily to bargain over. Now, where the union will try to find an issue when you say, we're not going to clean every day, they will question when you do clean every second or third day, is it greater work? Am I putting more onerous work on the housekeeper so that they're doing a different type of job? I find that argument to be specious. Basically, you can have a bunch of fraternity guys or sorority women in a hotel room on a weekend, and right now that's a tough job. I don't think that the fact that you haven't cleaned the room for 3 days for a guy like me or you who are pretty, business people in a room is going to make it much more difficult. The union thinks that because you're there for 3 days, all of a sudden there's more work to be done. So
Jay, you're gonna have to tell my wife how clean and organized I am. I think she would disagree with you.
All right, well, then maybe she should join the union. But the bottom line is that's the issue. But the key point is changing from daily cleaning to not daily cleaning is not a mandatory subject to bargaining. There's an awful lot that the unions try to say they have control over. And it's really important for owners, investors, developers, and managers to realize where the line is. You can't listen to the union to tell you what they have to do. There are specific rules, and you own or manage your hotel. Those are decisions about how you want to manage them. The issues of affecting the employees, the amount of work they do, may be something you have to negotiate, but the actual decision does not. The decision of cleaning rooms does not. And so what you have to do is figure out a way to change the cleaning protocols in a way that do not become onerous, or any changes are what they call de minimis. Sure, there'll be changes of things in the before pre-COVID. You had the issue about putting duvets in hotels, and the unions went crazy about the fact that they had to put an extra blanket on. Or there was a question about putting a refrigerator in a room, and who was going to clean that. Those would be the type of things that would be additional jobs that we'd be doing. But so long as you're sensitive to those things and how we make the changes, the idea of when rooms could be cleaned and how many are, and whether you have to clean every day, are not subjects of bargaining. Now, there are issues about what they say, quotas or credits. And one of the big things unions want to do is they want to reduce the number of quotas and credits because they think that this is more difficult work to do in the COVID world. That's, again, a matter of how you set up your health and safety protocols. So that has to go hand in hand. But the actual decision is not a negotiable item.
Great. I think most people don't really understand that. Even like seasoned industry professionals don't understand some of the things you're telling us.
Right.
So many of the hotels in major markets shut down in March, the second half of March or thereabouts, and thought they were going to be shut for 30 days, maybe 60 days. Now we're coming up on 6 months. It's been a big issue in New York City with the New York City industry-wide agreement in terms of triggering severance. How does this 6-month concept work in terms of the New York City hotel agreement, and does it work the same way in others? Is there contractual severance? How does that work?
The 6-month issue is a New York-centric issue. In other cities, you do not have this issue. There's a clause in the IWA, the industry-wide agreement in New York, that says that for a hotel that closes or remains closed for 6 months, then a certain severance kicks in. And it's really not a severance. A severance would be something when you no longer employed. It's a matter of providing additional compensation that basically has been put into the contract. So that's basically a New York-centric issue. And that's why there's so much of a concern in New York, where we have calls every day on, where in fact we have group calls with groups of owners or developers or management entities about how to deal with these decisions that are coming out from the so-called impartial chairman, who's making decisions interpreting this clause of the agreement. It's a New York contractual issue. It is not a statutory issue. It's not under federal labor law. The only thing I would say to note is when you are letting go of employees or you're keeping employees on the shelf, under something called the WARN Act, which is the Workers Adjustment, Retraining, and Notification Act, if people are no longer going to be working for more than 6 months, you have to give them appropriate notice. And most employers did that at the beginning, not realizing how long they would be out. Now that we've reached the 6-month period, those notices have had to be properly given. If they're not properly given, those of you who don't should give your notice now to avoid liability. But as to the issue of, is there anything magic about the 6 months? Only if it was agreed to in a collective bargaining agreement. And the place where that's most prevalent is in the New York City industry-wide agreement.
So it's just, I know it's just gone through in New York a series of arbitrations. Any light you can shed on sort of what the arbitrator ruled or came down with and what that means?
Yeah, what they're doing, what the impartial chairman in New York is taking a clause that speaks of that and basically is trying to bootstrap a way to provide benefits for the union members. I don't look at that as being a fair decision. And there are certain things in the decision that we have to look at. For instance, if you look at the clause in New York, it speaks about a closed hotel. Well, some hotels in New York remained open. And the question about, do you really have to pay a certain severance if you didn't close the hotel? Even if someone is out of work for six months, because it says closed hotel. Well, in contract terms, words have meaning. And there's some concern about whether that decision should be contested for hotels that remained open. Another issue deals with what's called the doctrine of improbability. The doctrine of improbability is when these clauses were negotiated back in the 1960s and basically have just been added on over the years. And they go back to the times when it was called Sheraton. That was before Starwood and obviously before Marriott. It was ITT Sheridan who basically developed a lot of these clauses and was developed by the former president of the union's father-in-law, who ran the New York Hotel Trades Council. Those things go back. At that time, no one ever considered COVID. Those things were done because a hotel closed for renovation. They closed because of business. They closed because of a change in brand. No one ever considered it to be a once-in-a-century pandemic that kills 200,000 people and basically shuts down a major city. So the question is, does that clause really apply in the circumstance we have now? And is the arbitrator really properly taking language that goes back to the 60s and properly applying that now? That's the doctrine of impracticality. It's really not practical for them to do that. So that's something we have to look at. As to the actual decisions, the decisions have gone back and forth. The issue was, the first decision, as many people may know, dealt with continuing health insurance for a period of 4 months. And then they reserved the issue about severance. Now,
the arbitrator punted on the severance issue several months ago, right?
Right. Then a decision came out and said, well, we'll pay, you don't have to pay, you can either pay severance now, and if you pay severance, you don't have to pay the health insurance, because the severance clause had 4 days of pay and 1 day to the health fund for each year of service, and then none of this 4 months issue. And then came up with this whole cloth idea that if you didn't want to pay a lump sum, you can pay as you go on a make whole. We'll take how much you made on a weekly basis. We'll deduct unemployment, and whatever remains, the employer will pay on a weekly basis. The basis of that was to ensure that when people come back to work, you wouldn't be paying all this money. There was $600 million were at risk if the arbitrator had actually said that every hotel would have to pay their severance. Talk about a rule of improbability or impracticality. That was never decided. So these decisions that are coming out are not really well founded. In fact, the arbitrator's decision in his first case in March used as the basis of it a hotel case in JFK Airport that went back to 2009 and said that was the basis for it. So we have to look at each hotel individually. You made a very good comment at the beginning. These are not one size fits all. You have to look at your individual hotel. You have to look at what you're planning to do. Did you really close? Was there an improbability? Is it going to make you bankrupt? Is it going to put you out of business? Are there issues about, and when you do the math, a hotel that has been around for 30 years to pay 1 week for every year of service, that's going to be an enormous amount of money. If you've only been there open 7 years, well, maybe it's a different. The 7-year I may want to pay a lump sum. The 30-year I can't pay the lump sum. And what's been missing is the fact that there's a real economic impact, and the arbitrator is totally not thinking about that.
So Jay, what happens if the owner just doesn't have the money? I mean, like, hotels are shut down, liquidity is run out, owners are paying huge amounts of property taxes, property and casualty insurance, all their fixed costs. What if they've got this kind of requirement under the arbitration and they just don't have the cash?
We have some hotels that are questioning this doctrine of impracticality. It doesn't apply to me. We have some that are, unfortunately, we have some clients that are saying, I'm going to try to renegotiate things with my lender. We have certain where they're trying to do deed in lieu conveyances, giving it back to the lender. We have some that are considering going into bankruptcy. The problem is that most hotels, frankly, entered into a IWA, which goes back to the present one, the industry-wide agreement goes back to 2012. Imagine that. It goes back 8 years and it's in place to 2026. And most hotels never even gave a thought as to the fact that they can have certain types of individual type of side letters, individual agreements. And no one ever considered it to be a COVID situation. So what happens? The idea of saying this is a COVID situation permits us to contest these type of programs, these decisions. And that's what has to, and so on a case-by-case basis, we have an innumerable number of hotels, some small, some mid-size, some extended stay, some select service, that we're looking at different ways to deal with this for the very reason. Can you imagine, $600 million would have been obligated to be paid if the arbitrator had followed the actual rules set forth in the industry-wide agreement. And that's why he didn't, because he knew he would devastate this industry. Well, the very fact that he came up with decisions made of whole cloth shows that there's no grounding in those decisions. And he's not basically sitting on a throne and comes down with an edict. And so on each hotel has to look at its own position and determine the best strategy to proceed.
Jay, do you know how long, just curious, do you know how long that arbitration took? I don't know, is it like a day, a half a day, 2 hours?
It wasn't very long. It took as long as filling a Supreme Court seat before Election Day.
I'm not going to go there. I thought this was, some of these topics were controversial enough. I'm not going to get into Supreme Court nominations.
But tell you, it was done very quickly. It was done very quickly. There really wasn't much consideration of these things. And listen, whenever you're dealing with the impartial chairman, it's an away game. And the idea is, how do we get out from under that? And that's only in New York. I must make it clear that New York has this unique situation of an impartial chairman. No other city in the United States has a practice where you can call for an arbitration on an emergency basis. You have an arbitrator that's ready to sit. and 90% of the time rules on behalf of the union. So other cities have been smarter than that. They've done a better job of that, and it's much more fair process. So I want all the viewers and listeners to understand that New York is not the way the rest of the world works. There are different ways to make deals. And frankly, we have been dealing with people in different cities with unions that have been much more cooperative over COVID than they've ever been. I've been doing this for a long time, and usually there's some type of pushback. There are certain cities, I would say in Chicago, in Los Angeles, in Pittsburgh, even in San Francisco, where we have gotten some reasonable deals because there's been some empathy. And that is something that should be realized. New York is a separate issue, but I think that that's going to come to that's going to come home to roost as well. I think some of these decisions are going to be contested, and they're not to the benefit of the owner or the developer or the management entity.
So Jay, we have a few, I think, very, very spot on participant questions. I'll try to go through a few of them quickly. First, if a hotel property is closed for 6 months and workers are laid off, if the property reopens as a hotel, does it have to be union? So let's assume the severance is, full severance is paid to every single union employee, and the hotel's shut for 6 months, or the hotel's shut for a year. It opens sometime next year. Is it bound by the union contract?
I get that question every week. Unfortunately, anybody who's subject to that has a contract that's good through 2026. That's the IWA. And because of that, the idea that you close, you pay severance, and employees, and you then decide to open later, you're bound. There is a bargaining unit that's in place. And under the National Labor Relations Act, there'll be an assumption that those employees that come back wish to be members of the union. You cannot decertify a union during the life of a collective bargaining agreement, or for a period of 3 years, whichever is shorter. So employees could decide to decertify the union since the contract has gone on more than 3 years. So there is an issue about whether or not people still want to be in the union after they come back. But if the question is, can I no longer be union? The answer is no. There's a bargaining unit. There's a contract that goes through 2026. Even if you were closed for a year and you reopen, under the National Labor Relations Act, which is the governing law, those employees are still represented unless the union takes the employees take the position that they no longer want to be represented. And in this case, since the contract is more than 3 years, they can do that, and there are ways to do that.
So Jay, staying on that same kind of topic, so if we close a hotel, we pay the full contractual severance, and say this is in New York, and the property reopens, do we have to hire back the same employees who we already paid severance to, or are we hiring different employees? How does that work?
Under the contract, employees have what's known as recall rights. Now, there are certain cities where if employees are out for a period of time, usually a year or 18 months or 2 years, depending on the city, they lose their right of recall. So if you're outside of New York, and I have to specifically distinguish that New York's a separate planet when it comes to these things. But in others, if you close for instance, a year in certain cities, and employees are no longer have recall rights to return to work. So therefore, you don't have to recall those employees. And so long as you're not doing that to avoid the union, but you're doing that based upon legitimate business reasons, you don't have to recall those employees. And that's part of the calculus when we deal on, like we said, each situation is customized. You don't have to bring them back. In New York, the employees do have recall rights that don't extinguish. So you have to bring them back in New York. Now, you have to offer them the opportunity to come back.
Right.
They may not come back, but you have to offer them the opportunity.
And Jay, what if we reopen, but business volumes are a third of what they were in 2019, right, for the next year or so? Who has those recall rights? Who are we calling back? We don't need them all.
And no one says you have to call back all the employees. So let's assume you have 20 housekeepers, but business is slow. It's just getting back on its feet. I only need 7. You only have to bring back 7 housekeepers. There is no obligation to bring back all 20. The other 13 do not have to be brought back. And you do not have an obligation to pay them. And you do not have an obligation to continue their health insurance coverage. They are, and that gets to our initial question, are they furloughed or laid off? What do we do there? And basically, we get to the position where we have our 7 employees under the contract. In most jurisdictions, you bring them back based upon seniority. That's a question that always comes to here in a COVID world. I have people who could do more things, could be multitask, are better employees. Can I bring back the better employees?
Right.
And unfortunately, under a labor contract, depending upon how it's written or whether you have a side letter, and we've done some COVID side letters because of that, to expand the work that's being done in certain properties. If you don't have that type of side letter, then you bring back based upon seniority. So you only have to bring back 7. No one says you have to bring back all 20. And you bring it back based upon your business needs. Again, remember, the union does not control the way you operate. It only controls wages, hours, and terms of employment, but not how the property operates, not what services you provide, not the staffing levels that you have, and not how long you stay open or closed. The people take the view that the union is in charge. The union's not paying your mortgage. They're not the one that are on your debt. They've never paid an employee. They've never made a contribution to the pension fund. They've never paid for health insurance. You're the one who's done that, and you make those decisions.
So Jay, we have another good question. The question is, how is the concept of enhanced severance being considered or negotiated for properties that are looking to convert or reduce in size of operation? Can you explain what enhanced severance is, and if you're seeing it, or why someone would go that route?
That's a great question, and let's talk about what that is. Enhanced severance is a fiction of the union. The collective bargaining agreements that, first of all, many collective bargaining agreements do not even have severance. There is no issue about you pay people. If you decide to pay people, severance is not statutory. It's not mandated by any federal labor law. What it has is basically you've contractually agreed to it, and you may not realize you contractually agreed to it because you just signed on to a contract that's been general in a city, and you never looked at it individually to negotiate separate terms. So assuming you have that, for instance, in certain cities, you pay 1 week for every year of service, and you could have a cap on that of up to 10 years. That's what would be in a contract. That's like paragraph A. But paragraph B says the union and the employer reserve the right to provide additional severance in good faith negotiation. And that's where they've come up with this idea of how much more is obligated to be paid. In the New York contract, for instance, if you close a hotel, you basically have to pay 1 week of pay. 4 days goes to the employee and 1 day goes to the fund, because the fund has to make their money, or 25% goes to the fund. And that's for every year of service. But in New York, there's been this enhanced severance fiction that has arisen that says we'll pay an additional amount, 1 week of 10 days pay for every year of service rather than 1 week, or 19 days rather than 1 week, or in the ANBAC situation when they took over the Waldorf, which is always thrown in people's face, the idea of 29 days for every week of service. Imagine that, 29 days for every year of service.
They had some very long tenured employees working in that hotel.
Exactly. So when you're an insurance company in China, maybe you can afford that, but that doesn't make the standard. So realize this whole issue of enhanced severance is a negotiated item. Now the union will tell you, you have to pay that or else we're going to have havoc on your property. But the idea is, to be direct, we have to be able to withstand that, quote, havoc, and there are ways to do that. And the best defense here is an offense. So there are hotels. There was a hotel that closed recently in the Washington D.C. area, and the actual severance was 1 week for every year of service with a cap of 10. In Washington D.C., the going rate was $2,500 for each year of service. When we spoke to the union, we said, we have no money. We're in COVID. We have no employees. We have no business. We will pay you our contractual obligation. When they said, well, we want enhanced, we said, you could fry ice. When there's no way we're going to do it. We don't have any money. So realize that this enhanced severance issue is a negotiated fiction. It's not in the contract. Your only obligation is to follow what's in the contract. And the enhanced severance is something that the union would like you to do. In good times, you may do it. In COVID times, very difficult to do.
So we've got another kind of interesting question, which is, does a New York City union hotel that's not part of the mass CBA, I would read that to mean the industry-wide agreement, have to adhere to its terms? Are there New York City union hotels that are not part of the industry-wide agreement?
Yes, and there are contracts with New York City that are part of the industry-wide agreement, but have very voluminous side letters. So if you have a hotel that's not part of the industry-wide agreement, you do not. The industry-wide agreement is basically was something that benefited the unions back in the 60s, because the union went to major players and said, we're going to give you certain benefits in the contract. And then for a competitive advantage, we're going to shove that down the throat of everybody else. So they basically, you have the wherewithal to pay it, they may not. And then you will increase your market share. I'm just being very direct. And basically,
that's what I love about you, Jay. You're always a wealth of information and very direct.
And basically, and the bigger players said, that's cool. We like having a competitive advantage. And so what happened is they did that. But the industry-wide agreement only applies to those hotels who signed on to the industry-wide agreement. It doesn't magically come out of the sky. And the industry-wide agreement can also be modified, and there can be side letters to it. And sometimes you have to give a little more here to get something elsewhere. You don't get things just because you're good looking, or you get things because you're giving something
for yourself.
That's a phrase that's only good for radio. So basically, you give you may have to trade something. A lot, like for instance, unions wanted to get rid of green programs. They didn't like the idea of having green programs because there would be less hours that would be worked. If you said, I will not get rid of green programs, you may have been able to get some type of change in room quotas. There's always a trade. So you have to think about what's the thing that the union wants. Right now, the union is concerned about technology. There are major technology clauses. In the Las Vegas contract, there's like 6 pages of not changing technology, giving 180 days advance notice. Why is that? Because they don't want to lose jobs. So if you're willing to trade, there's something I want and something you want. It's almost baseball playoff season. I need a pitcher, you need a shortstop. I really don't care about your infield, and you don't care about my pitching. But if I get a pitcher because it's important to me to help me run my business, I may be willing to give up that shortstop. That's what you have to do. So deals can be made. The industry-wide agreement only applies to those who want to sign on to the industry-wide agreement. The industry-wide agreement doesn't have changes only because you haven't sought those changes, or you haven't been willing to deal. And what we do, almost every hotel that we represent has some type of side letter. And they're unique. They're unique to specific hotels because of the way they operate. And sometimes you pay a lot of money for your changes, but sometimes it's a big payment now for a short-term payment for a long-term gain. Because once you pay it out now, you then have an opportunity to change the way you operate for years and years and years. And if you decide you want to sell your hotel later, and you have to have a successorship clause that makes somebody take your contract, it becomes much more attractive to have a contract that doesn't have an onerous term of the IWA that you bought out.
So Jay, so clearly when there's a negotiation, we'll stay on New York City for a minute, the union is representing itself, right? They may have outside counsel helping them, but they're on one side of the negotiation. Who's on the other side? If I own a hotel, am I negotiating, if I own a hotel in Times Square, am I negotiating directly with the union over the industry-wide agreement? How does that work?
Yeah, I mean, we're in negotiations now where we are negotiating our own deal for a number of hotels, some of which got organized. The union made a major push to organize hotels, especially towards the southern part of the island. And some of those players do not want to be part of the IWA. It doesn't apply. 1,000-room hotel in Times Square, the terms of that contract don't apply to 120-room transient property down on 29th Street. It just doesn't apply. Or you have a lifestyle property that European lifestyle properties, they don't fit into the same type of property as a New York Hilton or a New York Sheraton or the Waldorf Astoria. In those contracts you have clauses which say you have distinct jobs, pot washers and dishwashers. Well, if you go to a lifestyle property, that's not the case. You go to hotels that have check-in by kiosk. That's not the case. You have hotels where you go in and people, you have an open kitchen and people ladle their own soup. That doesn't apply. The union contract is for major convention-type properties in New York. That's where it's modeled after. And so what you need to do is you need to develop your own contract to meet the needs of your own hotel. And therefore, when the union says this is our general contract, that's great if you have 1,000-room convention property. And also it's great at pre-COVID. But now after COVID, I don't know how those hotels are going to work, and neither does the union. So we're negotiating our own contracts.
So basically, a limited service hotel can't afford the same expense load and types of expenses as, a 1,000-room full service convention hotel.
Absolutely. Absolutely. Remember, in the New York contract, and I know there's the rest of the country, we're spending a lot of time in New York, and that's fine, but you're paying 1/3 of your gross payroll to pension and health insurance. That you're not paying by hours worked. You're not paying a set amount. You're taking a percentage of about 1/3. If you have $1 million of payroll, you're paying $333,000 to funds. If you multiply that by 10 or multiply that by how much, that's an enormous bucket of drag. And that makes the health funds happy and makes the pension funds happy, but you don't get a direct benefit from that. And so that's why you have to be strong on how you negotiate those things. Remember this, terms of a contract cannot be imposed upon you. It's only if you agree to those terms. There is no such thing as a New York industry agreement that you automatically get because you have a hotel in New York that gets unionized. Or in Chicago, or in San Francisco. There may be models that major players have signed on to, but you have to look at your individual property and negotiate for individual property. And there usually is a trade-off. The union wants to get something from you, and we're willing to do that, and we're willing to give them something. And a lot of times it comes with money. And when I say money, I don't mean underhanded payments. I mean you pay for something to the employees or something the union wants, and you get something else in return. But they should be individually negotiated.
Okay, very interesting. So in terms of negotiations, one of the things going on right now is a lot of lender negotiations between borrowers and lenders for forbearance. Some of that is leading to handing the keys back, or discussion of deed in lieu conveyances, like handing the properties back to lenders. If I'm a borrower and I, call my lender and say, hey, I'm sending you the deed, congratulations, you now own this hotel. How does that work? Do any of the union obligations go away? Is the lender bound by the union contract? How does that work?
We represent a lender that has ended up with 22 hotels is deeds in lieu. Basically, people can't make it. They have worked out an arrangement rather than a foreclosure. And now we've gotten a call from this specific lender, which is a major lender, who says, what am I supposed to do? Pro to your question. The first thing is most of the collective bargaining agreements have a successorship clause. The lender is basically standing in the shoes of the owner and maybe even standing in the shoes of the manager. As a result of that, that successorship clause must be honored by the lender. So now I have lenders who are obligated to a collective bargaining agreement. They may understand how to give out mezzanine loans, but they don't know anything about PTO, and they don't have any idea about how to schedule employees. But they are stepping in the shoes because they're obligated under the collective bargaining agreement. So in a deed in lieu, when you give back the keys, the major obligation that the borrower has to do is to ensure that the successorship agreement is honored. Because in the collective bargaining agreement, the borrower made a promise to the union that should there be a conveyance or a transfer of the property, anybody who took over the property would honor the collective bargaining agreement, would assume the collective bargaining agreement, would adopt the collective bargaining agreement. And that is an obligation that has to go forward. So the lenders kind of look at me and say, well, why am I taking a contract? Because you either, if you don't take the deed in lieu, and even if you foreclose, someone else takes over, you may also have to take that obligation. So that's the key. In the 22 hotels that are being taken over by this one lender, and there are many more, they now are stepping in the shoes of being having to honor a collective bargaining agreement. And what we're doing is we're advising them, because for them, it's like going to Mars. They have no idea how to deal with these collective bargaining agreements. And we're then sitting down with the union and saying, we want to keep this hotel afloat. We have employees. Remember, the union represents employees. They don't represent properties. They represent employees. And as a result, the employees, if you want your employees to come back to work, you gotta work with the lender. And that's where we are in some of these COVID negotiations.
So if there was a deed in lieu, do the severance payments transfer as well? And then the lender who becomes the owner is then responsible for severance that was incurred?
Yes, or however you work out the deed in lieu. Those obligations have to be honored. They don't go away, as opposed to a bankruptcy where you can reject, a bankruptcy court could reject a contract. A deed in lieu just puts the lender in the shoes of the owner or the borrower who's obligated under the collective bargaining agreement. Now, that severance could be something that's discussed as part of the conveyance, and maybe the borrower pays that out before, or most likely they don't have the cash to do that. But if they don't have the cash to, yes, that's going to become one of the lender's obligations.
And you mentioned, a bankruptcy that can make the contract go away. How does it work? Can you reject a collective bargaining agreement during a bankruptcy process? Is that common? Do you think that will happen in the next couple of years?
I think you're going to see more of them. Let me just give you a brief outline of what happens. A entity that believes that they can't go forward and operate and wants to declare bankruptcy has to make a good faith effort to renegotiate the contract with the union. The probability is the union will not agree. If the union agrees, great, then I don't have to go bankrupt. I want to reduce my PTO. I want to hold off on severance. I want to have a wage freeze for 2 years. I want to change my health insurance. You go and you say to the union, I want to change this because economically I cannot keep this going. I want to keep my hotel open and I want to keep your members employed. The union tells you to go south. And basically, then you declare bankruptcy. The bankruptcy court says to you, did you try to renegotiate this contract? The answer is yes. Did you do it in good faith? Yes. And what did the union say? The union said, go someplace, but we're not going to make a change. if I make a change for you, I'd make a change for everybody else. That's their old line. By that, a bankruptcy court has the right to reject the collective bargaining agreement, so long as the hotel has made its best efforts to try to modify the contract. If it can't modify the contract with the union, the bankruptcy court has incredible latitude to be able to do that, and can in fact reject the contract, and can indeed tell the parties to sit down and start bargaining from scratch. That hasn't happened a lot because most people don't want to go into bankruptcy. But in this COVID recovery, and I've never used the term post-COVID because I don't know when that's going to be. But in the COVID recovery, I think we're going to see a lot of, not a lot, but a significant number of owners or hotel operators realize that bankruptcy may be a way to go. And I think that the union is concerned about that, because if you go to bankruptcy, it's a good leverage point. That contract goes away. And if that contract goes away, then severance may go away, the use of the impartial chairman may go away, successorship may go away, neutrality may go away, which are very important issues in the collective bargaining agreements, not only in New York, but around the country. So that's something that has to be considered whether bankruptcy is a viable option.
I'm betting that there will be a lot more bankruptcies over the next few years. Are you able to do a prepackaged bankruptcy structure? So do something where you work out with your lenders, and as part of that, you either reject or materially change the terms of the union contract?
You can't do it with your lender. Only a bankruptcy court could reject the contract.
Okay.
So you can't just do it with a lender. But remember, the unions are going to have to get smarter, because they're going to have to realize that if I go to bankruptcy, they lose their leverage. Now, there's a lot of negativity to a borrower to declare bankruptcy, and people don't want to do that, and affects credit ratings and all the rest. But that is an option out there. There are a number of options. One option is to just is to renegotiate your contracts. Two is but the most important way is really to reposition your hotel. That is one that every owner, developer, management company has to sit down and say, I cannot operate my hotel in 2021 the way it operated in 2019. It's impossible. It's not going to be that way. And whether you're in Chicago, San Francisco, San Diego, Nashville, New York, Miami, it's just not going to be that way. And so how do you reposition your property? That's the best way, not only from a business standpoint to keep your property successful, but also from a union standpoint. And a lot of the ways to reposition, again, so one of the themes we've discussed over this hour, you do not have to negotiate the repositioning with the union. So to know where that line is so important. Some things you can do on your own, and some things you need to speak to the union about. If you know the difference, you know where the leverage points are, you can come out much better, even though you have a unionized property.
So, Jay, we've hit our 1 hour mark. I could do this for the entire day. I always enjoy speaking with you, and I always learn some things. I took some notes as we went here, and I thought I knew this material, but I've learned a few things, and I do have some questions to ask you later. But I would reiterate again for all the participants who are live now, as well as anyone who listens to the recording, there's no one answer that applies to everything, every situation, every hotel situation. Collective bargaining agreement, set of labor issues is unique. So seek competent counsel. I reach out to Jay. Hopefully you're smart enough to do that as well. And if not, reach out to someone who's almost as good. But Jay, on behalf of all the participants, on behalf of the team at JF Capital, thanks for your time, for your words of wisdom. And again, anyone looking for guidance, it's Jay Krupin at BakerHostetler, and you won't be disappointed if you reach out to him.
Well, thank you very much. It's great to be here, and I hope everyone stays well.
Thanks, Jay.
Bye-bye.